MJ Denman, D-E-N-M-A-N.
Andrea, your reaction to what just happened this morning?
Utterly disappointed. Unfortunately, my clients might hear it from you guys before they get to hear it from me. We were so sure and remain confident that our interpretation of the statutes in Oklahoma are correct. In short, one judge disagrees with another judge, so we're going to go ask a third judge. Your elected district attorney files thousands of cases every year, and every single one of them starts with "in the name and under the authority of the state of Oklahoma." Your tax dollars are at work right now litigating a 14, a 15, and a 16-year-old boy who did nothing sexual at all. No clothing was removed, no penetration was involved, and yet your elected DA and your tax dollars want these boys to be convicted as adults and making them sex offenders. And it's quite ridiculous.
MJ, from a legal perspective, can you just kind of describe what we saw a few weeks ago and then basically what we saw from Judge Smith this morning?
Well, what we saw a few weeks ago was a special magistrate deciding that the strict construction of the statute was that she had to follow 10A, Title 10A, and that it demanded shall be filed as a youthful offender under this section. What we've discovered is apparently there's an alleged conflict of law. The issue that's truly troublesome is this. When this case came before whoever the intake prosecutor was, and if you actually saw there was a conflict of law, okay, which is what the state's claiming. They're saying, look, Title 21 says we can file this as an adult. Now, whether they knew it or not, January 15th, they knew when I filed a motion to dismiss, the Title 10A says, no, you don't. You shall prosecute as a youthful offender. Well, the prudent thing to do with the adults in the room, if you thought that it was a conflict of law, would have been, instead of taking a metaphorical wrecking ball to three kids' lives, three children's lives,
Families' lives.
what you would have done was you would have prosecuted it as the statute says, shall as a youthful offender, and then you would have solicited, as the DA council does, to the legislature and says, we need you to clean this up. We don't understand it, but we're not going to wreck three children's lives and their families by doing this. We're going to clean up this statute. That's not what was done. So now we have this mess.
So Judge Smith's interpretation is that rape by instrumentation does qualify for prosecutors to have the discretion to charge an adult.
As we argued prior to this, 10A is a title of criminal law and statutes that is articulated for 18 and under. In the state of Oklahoma, that was put in place to protect children and to have them processed through the criminal process in a much different fashion. That is 10A controls over 21. What the judge is saying is that that is not the case. That 21 controls over 10A, which then gives the district attorney's office unfettered control and ability to do whatever they want with 18 and under. That is not what the legislature intended. That is not what they did. The language is very clear in that statute. And we can sit here and talk all day long about, well, the language is a little different, and if we got to go to Title 21, and we can get very technical about it. But here's the question. If the legislature wanted it to be this way, if the legislature thought that this was the correct decision, then why do they go through such a long articulation of, once somebody's a youthful offender, there's a procedure that the state has to go through to bridge them to an adult under aggravating effect? Why would they go through that procedure? That the court did not recognize that that procedure was put in there by the legislature. It didn't recognize that with the same level of balance to say that is in there because this particular statute in 10A controls. I believe that that was ignored, and in balance, what the court is doing is saying to the state of Oklahoma through their DA's office that you can charge it and you have control, not the legislature. And to be fair, that frustrates me as a trial attorney because over and over and over again, I hear the state of Oklahoma, the DA's office, get up in front of juries and go, you don't get to make the law. The court doesn't get to make the law. The legislature makes the law. Well, guess what? The court just made the law.
Basically, Seibert Rule 10A applies, and that's why it was dismissed. Judge Smith is saying that 21 overrides 10A for rape by instrumentation.
For simplicity's sake, we're doing a lot of legal maneuvering to argue about whether or not the DA has discretion in this case to make these kids adults. What we're losing sight of in all the legal maneuvering is that they have the discretion, and discretion carries responsibility and necessarily the use of common sense. If you stop and look at the facts, which we will eventually get into, we haven't even gotten a chance to get into, you'll see that even with wide discretion, even if Judge Smith is right, the appropriate decision with the discretion that they have would be to keep treating these children like children. That said, we will continue to fight. I believe all of us will continue to fight on behalf of these children and these families and everybody else who may be taken advantage of with this discretion that is enormous power on behalf of not only our elected DA, but every single one of his assistants that he hires.
I would agree.
Anything else? I'm good. You guys?
I mean, what's next for you guys? What's the next plan of action?
I think we're gonna go to the Court of Criminal Appeals, which I believe we all think we should have been at today anyway.
Yes.
That is true. This is an issue that's going to have to be, and this is the other problem. Had the court found in our favor, it would have been expected that the state would appeal its decision. So then it would be the state, and these are the mechanics. The state would file an appeal on this decision asking for a writ of prohibition or a writ of mandamus, depending on whichever one applied. And then we would wind up being the respondents if it was necessary. Now, because of the way this decision was made, we're going to have to individually appeal and make sure that it's fast-tracked because we're dealing with children and the clock is running. And then they'll have to respond if the court deems that it's necessary. That's where we are mechanically.
Did he set prelim for 26?
He did. He remanded it down because Judge Seibert dismissed the case. Essentially, he overruled her, undismissed the case, and sent it back for prelim. That would be the next step if we weren't going to continue to fight on behalf of these kids and their families, but we'll continue to fight.
Right.
We'll go where we're supposed to go, where we're ordered to go, and we'll continue to argue what we believe is a very, very clear interpretation of the law. But I believe our next step will probably end up being Oklahoma City.
So they're recharged as adults.
Yes.
Yes.
What Clint undid what April did.
Gotcha.